the Protection of Women from Domestic Violence Act 2005, Dowry Prohibition Act 1961, Dowry Prohibition Maintenance of List of Parents and Bride and Bridegroom Rules, Family Courts Act, and Personal Laws Amendment Act, and Bharatiya Saksha Adhiniyama and Civil Procedure. These are the important laws which are required to be acquainted with the persons who are practicing or dealing with the matrimonial cases. Then the facts which are family court, nature of types of the cases before the family court. Under the section 7 of the Family Court Act, what are the matters to be dealt by the family court is described. I have categorized 10 category of matters will become before the family court. One is either nullity of marriage or declaration as to the validity of marriage or marital status. Then restriction of conjugal rights, judicial separation, divorce petitions, maintenance, child-related issues like guardianship of a person, custody of or access to any minor, property of the parties to the marriage, or injunction suits. These types of categories of cases will come before the family court. Then I have made a sections which are relevant sections under the different personal enactments. The Hindu Marriage Act, section 5, 7, 11, 12 are with reference to marriage. What are the conditions of a valid marriage, ceremonies of a marriage, then void marriage and voidable marriage. Then section 2 of the Anand Marriage Act deals with validity of Anand marriage. Section 4 and section 5, RM Marriage Act, section 2, Hindu Marriage Validation Act is section 2 will deal with about the how marriage is. Under the Indian Christian Marriage Act, part 1, part 3, part 5 and part 6 provisions will deal with the how marriage will be solemnized, what is the before whom marriage may be solemnized, grant and revocation of a license to solemnization of marriage, time for solemnizing the marriage, place for solemnization of marriage, other details are given. So also section 60 to 65 and section 88 deals with the validation and non-validation of marriage within the prohibited degree. Then with reference to marriage and nullity of a marriage with the conditions of a marriage, with reference to Special Marriage Act, we have provisions section 4, 5, 7, 8, 10, 11, 12 and 13 and chapter 4 and section 19 and 221A, and the nullity of a marriage will deal with section 24 and 25. These provisions are with reference to Special Marriage Act with reference to validity of a marriage and nullity of a marriage and matrimonial status. Then Parsi Marriage and Divorce Act, section 3, 4, 10 and 30 will deal these matters. Then Foreign Marriage Act, section 4, conditions relating to solemnization of marriage, it will deal. Section 5, notice and how the marriage will be solemnized and publication of a notice, objections, solemnization of marriage when no objection is made, when objections is made, how the solemnization of a marriage will come into force. That is with reference to Foreign Marriage Act. I have mentioned only provisions section 11, 12, 13, 14 and 15. Then going to the next topic is the restriction of a conjugal rights. The relevant provisions of different personal laws. Section 9 of the Hindu Marriage Act deals with the restriction of conjugal rights. Similarly, section 32 of the Divorce Act, section 36 of the Parsi Marriage and Divorce Act 1936, section 22 of the Special Marriage Act, and section 18 of the Foreign Marriage Act. Judicial separation. Section 10 and 13A of the Hindu Marriage Act deal with the judicial separation. Section 10 and section 13A. 13A, if court comes to the conclusion that divorce is not alternatively instead of divorce prayer, the court can grant judicial separation. Section 22 to 25, Chapter 5 of the Divorce Act deals with the judicial separation. Section 34 of the Parsi Marriages and Divorce Act, it will deals with judicial separation. Similarly, Special Marriage Acts, Section 23 and 27A, and Foreign Marriage Acts is Section 18 and read with the Special Marriage Act. Then divorce. The divorce petitions, we are required to acquaintance with these all provisions under the different personal laws. Section 13 and 13B of the Hindu Marriage Act, Section 2 of the Dissolution of Muslim Marriage Act, Section 5 of the Muslim Personal Laws Shariat Application Act 1937, Section 10(a) of the Divorce Act, Sections 31, 32, 32A, 32B of the Parsi Marriage and Divorce Act, Sections 27 and 28 of the Special Marriage Act, Section 18 of the Foreign Marriage Act read with provisions of Special Marriage Act. With reference to maintenance, Section 24, interim maintenance, Section 25, permanent alimony, Section 26, child maintenance and educational expenses of the Section 26 of the Hindu Marriage Act deals with these provisions. The Hindu Adoption and Maintenance Act, Sections 18 deals with maintenance of wife. Section 19 deals with maintenance of widowed daughter-in-law. Section 20 deals with maintenance of children and aged parents. Section 22 deals with maintenance of dependents. Section 27, maintenance when to be charged. Then Muslim Women Protection of Rights on Divorce Act, the Section 3, rights on other properties, and Section 4, order for payment of maintenance. These are with reference to maintenance. Section 36, permanent alimony. Section 37, permanent. Section 36 is the interim maintenance. Section 37 of the permanent alimony. Section 38, direct payment of alimony to wife or to her trustee. That is with reference to the Divorce Act. Under the Special Marriage Act, the Section 36 deals with interim maintenance. Section 37 deals with permanent alimony. Foreign Marriage Acts, Section 8, all reliefs are governed under Section 18 of the Foreign Marriage Act. Marriage Validation Act, Section 3. Then with related to child-related issues, custody-related provisions are Section 26 of the Hindu Marriage Act deals with the custody of the child, and Section 6 of the Muslim Protection of Rights on Marriage, Section 41, power to make orders as to the custody of the children in a suit, and Section 42, powers to make such order after decree. Section 43, power to make orders as to custody of a children's suit for nullity. Section 44, power to make such orders after a decree of confirmation. Section 49 of the Parsi Marriage Act and Section 38 deals with the custody and also Guardian Arts Act provisions. Here, I fairly confess that it is not possible to cover all the above said provisions of these enactments in detail in a given time. I am focusing only provisions of Hindu Marriage Act with reference to divorce, as we all of you know that major matrimonial cases are come under the Hindu Marriage Act, and by comparative study of these Hindu Marriage Act and other personal laws, in all personal laws, the cruelty, desertion, adultery, and incurable mental disease are all the grounds for divorce. There is a common, the little bit, some except barring some exceptions. The similar provisions are there. Therefore, today I am focusing only the major ground cruelty, especially mental cruelty, and the desertions. More large number of cases are on these two, Section 13(1)(a) and Section 13(1)(b) of the Hindu Marriage Act we come across. Therefore, I am focusing more on those facts. Coming to the Hindu Marriage Act, important provisions. I want to deal with important provisions of the Hindu Marriage Act. Section 1 of the Hindu Marriage Act is different than other legislations. That is, this act may be called the Hindu Marriage Act 1955. It extends to the whole India. In other enactment, we come across that it extends to whole India only. But the section 1 subsection 2 say that it extends to the whole of India and applies also to Hindus domiciled in the territories to which this act extends, who are outside the state territory. From this provision, it is clear that the application of the act is beyond the territory of India. It is applies to the Hindus who are resident outside the India. Therefore, section 1, subsection 2 of the Hindu Marriage Act is important. Then I will directly go to section 5. Section 5 deals with conditions for Hindu marriage. A marriage may be solemnized between any two Hindus if the following conditions are fulfilled. Here I will stop. A marriage may be solemnized between any two Hindus. The application of this Hindu Marriage Act is only to the marriages between two Hindus. If one Hindu and one spouse is Hindu, another spouse is non-Hindu, then this Hindu Marriage Act is not applicable. Even though before starting the condition number 1, a marriage may be solemnized between any two Hindus if following conditions are fulfilled. First condition is that neither party has a spouse living at the time of marriage. Second is, at the time of marriage, neither party is incapable of giving a valid consent to it in consequence of unsoundness of a mind. B, though capable of giving valid consent, has been suffering from mental disorder of such a kind or to such an extent as to be unfit for marriage and procreation of a children, has been subject to recurrent attacks of insanity. Third condition is the bridegroom has completed the age of 21 years and the bride the age of 18 years at the time of marriage. Then fourth condition is that the parties are not within the degree of prohibited relationship unless the custom or usage governing each of them permits of a marriage between the two. Fifth condition is the parties are not subpoenas of each other unless the custom or usage governing each of them permits of a marriage between the two. These conditions, what is the effect of violation of that conditions is provided under section 10 and 11 and 12. Section 11 deals with void marriages. Any marriage solemnized after commencement of this act shall be null and void and may, on petition presented by either party thereto, be so declared by a decree of a nullity if it is contravenes any one of the conditions specified in clause 1, 4, and 5 of section 5. 1. Neither party has a spouse living at the time of marriage. And 4, parties prohibited degrees, and 5, subpoenas. Here I want to give one example which I have dealt with as a principal family court judge. The suit is filed by the husband. Petition is filed by the husband for declaration that marriage is a nullity. It is his specific case that as on the date of their marriage between himself and respondent, the respondent has got living spouse. Even though she has filed a petition for divorce with reference to her first husband, that petition for divorce was pending, and during pendency of that petition, they have undergone marriage. Therefore, under section 5 and 11 of the Hindu Marriage Act. First condition, 5.1, neither party has a spouse living at the time of marriage. This marriage is void. During the marriage between the petitioner and respondent, they have got blessed with one child. After issuance of notice, the respondent appeared. Her specific case is that she has admitted the subsistence of marriage, her first marriage, and she has taken contention that her first husband and petitioner are the friends. Petitioner has attended her first marriage, and he knows that pendency of a divorce petition, and he has assured her that the marriage will be kept unknown to general public. So, secret marriage, it is a secret marriage. We will declare our marriage only after the divorce was obtained from the court with reference to first marriage of the respondent. In view of that assurance, I married. Now, my question is, I put my question to myself that whether under the provision of section 5 and 11, combined reading of section 5 and 11, whether such defense is maintainable. She might have been other reliefs like he has cheated, or she is entitled for maintenance, or he has entitled for compensation, the child has got maintenance or property right in the property of the biological parents. The other reliefs might be available. Whether in such a condition, admitted fact that the marriage was solemnized during the subsistence of marriage of the respondent with first husband, whether marriage is void or not. In the objections to the main petitions, he has admitted the same. Therefore, in view of section 5 and 11, the first condition was violated by both parties. Both have, that is a bigamy, they have committed a bigamy. The knowledge of the petitioner that divorce petition is pending will not validate the marriage. That is, it is contrary to section 5 and 11 of the Hindu Marriage Act. The void marriage means void ab initio. Under law, it is not a marriage at all. Then other conditions are there. Prohibited degree, we will come across mostly section 5 or subsection 1. Then voidable marriage, section 12 is the voidable marriage. We have got petitions, several petitions will be filed under section 12 of the Hindu Marriage Act. Section 12 of the Hindu Marriage Act deals with the voidable marriages. Any marriage solemnized, whether before or after the commencement of the act, shall be voidable and may be annulled by a decree of nullity on any of the following grounds: that the marriage has not been consummated owing to the importance of the respondent. I will stress here that the marriage has not been consummated in several pleadings we come across. It will be pleaded that marriage was not consummated. But ground of void, to declare a marriage as a void under section 12, that the marriage has not been consummated owing to the importance of the respondent is also second ingredient. First ingredient is marriage not consummated, and second ingredient is owing to the importance of the respondent is also required to be proved and substantiated by the parties. And that the marriage is in contravention of the conditions specified in class 2 of section 5. Class 2 of section 5 is the consent with reference to minor unsoundness of mind. Consent was not free consent. That it will deal with that.
Small request, sorry to interrupt you. Slides change ಆಗ್ತಾ ಇಲ್ಲ ಅಂತ ರಿಕ್ವೆಸ್ಟ್ ಮಾಡ್ತಾ ಇದ್ದಾರೆ ಪಾರ್ಟಿಸಿಪೆಂಟ್ಸ್. ಸ್ಲೈಡ್ಸ್
ಒಂದು ನಿಮಿಷ, ನಾನು ಪ್ರೊವಿಷನ್ಸ್ ಇಷ್ಟು ಹೇಳಕ್ ಆಗೋದಿಲ್ಲ ಅನ್ನೋ ಕಾರಣಕ್ಕೆ ಮಾತ್ರ ಅಷ್ಟೇ ಮಾಡಿದೀನಿ ಸ್ಲೈಡ್ಸ್ ಅನ್ನ.
All right, ma'am. Thank you for the clarification.
Yes, sir.
Sorry for interrupting.
Yes. ಮುಂದೆ ನೆಕ್ಸ್ಟ್ ಒಂದು ಸ್ಲೈಡ್ ಇದೆ, ಅದು ಸೈಟೇಷನ್ಸ್ ಇದೆ, ಅದಕ್ಕೆ ಅದನ್ನ ಹಾಕಿಲ್ಲ ನಾನು. ಇವಕ್ಕೆಲ್ಲ ರೈಸ್ ಮಾಡ್ಲಿಲ್ಲ ನಾನೇ ಓವರ್ಲೆ ಹೇಳೋನು ಅಂತ ಹೇಳಿ ಅನ್ಕೊಂಡು.
Sure, ma'am. Thank you.
Okay, thank you. Then marriage is in contravention of the conditions B and C. We can go that the consent of the petitioner and consent of the guardian in the marriage of the petitioner under section 5 as it stood immediately before the commencement of the child marriage restraint act. The consent of such a guardian was obtained by force or fraud, then it is a voidable marriage. That respondent was not at the time of marriage was pregnant by some person other than the petitioner. And section 2 will deal with when the petition is required to be filed, if fraud is disclosed or coercion is taken away, then within 1 year, these provisions are, I will not deal with that in detail. Then other important provisions in Hindu Marriage Act is ceremonies of marriage and section 7, ceremonies of marriage. The Hindu marriage may be solemnized in accordance with the customary rites and ceremonies of either party thereto. Where such a rites and ceremonies includes the Saptapadi, the marriage become complete and binding when the 7th step is taken. It is section 7. Then most important, then coming provision is section 13. Section 13, the grounds of marriage, the grounds of divorce. Any marriage solemnized, whether before or after the commencement of this act, may on petition presented by either the husband or the wife be dissolved by a decree of divorce on the ground that the other party has, after solemnization of a marriage, had voluntarily sexual intercourse with any person other than his or her spouse. This is first ground. And second ground is 1A, has, after solemnization of a marriage, treated the petitioner with cruelty. Day in and day out, we are required to deal with this provision, section 13(1)(1)A, cruelty. Especially cruelty includes mental cruelty. Then most used provision is 1B, has deserted the petitioner from continuous period of not less than 2 years immediately preceding the presentation of the petition. And has not incurable diseases there. Most common petitions will be filed under section 13(1)(1)A and 1B, and some few cases will be filed under section 13(1)(1), that is adultery, and incurable disease, unsoundness of mind, we can come across few cases. I will, before discussing cruelty, I want to discuss section 9 for 2 minutes. Section 9 of the Hindu Marriage Act. Restriction of conjugal rights. When either the husband or the wife has, without reasonable excuse, withdrawn from the society of the other, the aggrieved party may apply by petition to the district court for restriction of conjugal rights, and the court, on being satisfied of the truth of the statement made in such a petition, and that there is no legal ground why the application should not be granted, may decree in restriction of conjugal rights accordingly. Here I will focus to grant a decree for restriction of conjugal rights. The pleadings of the parties are with reference to 2 facts. There must be a withdrawal from the society of the other spouse, that is without reasonable cause. I focus on without reasonable cause. If there is a cause for withdrawing the society of the other spouse, then decree for restriction of conjugal rights will not be granted. Here I can give examples that both husband and wife are working in different cities. For any reason, for a long time, they are not able to meet each other. That will not be a ground for restriction of conjugal rights. The without reasonable cause, withdrawing of the society is needed. The court will, at the time of passing a restriction of conjugal rights decree, court will look into the matter that whether it will be required to satisfy itself that the truth of the statement made in the petition, what are the pleadings made in the petition are required to be satisfied. They are the true facts. Court is required to satisfy that they are the true facts. And other is there is no legal ground why the application should not be granted. After satisfying these two conditions, then only the court will pass decree for restriction of conjugal rights. Then judicial separation, section 10, judicial separation. Judicial separation, all grounds are available under section 13 are available for judicial separation. Instead of seeking divorce, the party can opt for judicial separation under section 10 of the Hindu Marriage Act. Now coming to the ground, most day-to-day require cruelty ground, I will deal with section 13(1)(a) of the Hindu Marriage Act, cruelty. All of you know that the word cruelty has not been defined. It has been used in relation to human conduct or human behavior. It is the conduct in relation to or in respect of matrimonial duties and obligation. The cruelty may be physical or cruelty may be mental. Cruelty may be intentional or unintentional. If it is a mental cruelty, the inquiry must begin to the nature of cruel treatment. And next, the impact of such treatment on the mind of the spouse. In dealing with mental cruelty, the court is required to decide on the pleadings and evidence placed before the court that what is the nature of the cruel treatment and what is the impact. Impact is more important. Impact of such treatment on the mind of the spouse is important. The degree of tolerance in deciding the cruelty, we are required to look into several aspects. The degree of tolerance varies from one couple to another. Therefore, background, level of education, status of the parties are required to be considered while considering the mental cruelty. To understand more clearly about the mental cruelty, I want to discuss the facts of 3 reported judgments. Whether particular act, behavior of the party amounts to a mental cruelty to the other spouse or not. Fortunately or unfortunately, the chosen 3 cases are filed by husband against the wife alleging the mental cruelty. With reference to, I will give the citations letter in the PPT. It is mentioned. First I will give only facts of the case, and we can discuss whether they are sufficient or not to come to conclusion that there is a mental cruelty or not. In the first case, the husband is the army officer with M.Tech qualification. Wife is a faculty in government PG college. Within the 1 year of the marriage, the difference arose. They will reach to an extent that they are separated. Wife has alleged adultery against the husband, and she has lodged complaint to the superior officers of the husband. In view of the complaint lodged by wife, the army authority has conducted inquiry against the husband. It is the case of the petitioner husband that, in view of character assassination by the wife, by lodging such complaints and approaching the Women Commission, in view of inquiry conducted by Army Authority, his initial career in the Army Department was affected. And in turn, there is a character assassination, and there is no possibility for him to lead marital life with her. On the contrary, the wife has taken contention that respondent is having a extramarital relation, adultery, and she lodged a complaint to save the marriage. And she filed a petition for restriction of conjugal rights, for issuance of direction against the husband to join the company of the respondent. Both divorce petition as well as petition for restriction of conjugal rights were tried together. The family court has come to conclusion that the adultery ground was made, allegation of adultery was made by the wife, but she has failed to prove the same. And he has filed malicious complaints before the higher authorities of the petitioner, which is sufficient to come to conclusion that there is a mental cruelty to the husband, and granted divorce to the husband and rejected the petition filed for restriction of conjugal rights by the wife. The wife preferred appeal to the High Court, challenging the judgment and decree passed by the family court. The High Court has, by observing that there is no finding of any court with reference to the allegation of adultery made by the wife is false. Therefore, mere lodging of a complaint to the higher authorities does not amount to mental cruelty, and set aside the judgment and decree passed by the trial court. Challenging the same, husband has went to the High Court in Supreme Court in civil appeal. The Supreme Court, in dealing with that case, has drawn some principles. That is, the degree of tolerance varies from one couple to another, and the court will have to bear in mind the background, the level of education, and also the status of the parties in order to determine whether cruelty alleged is sufficient to justify dissolution of marriage at the instance of the wrong party. And reverse the judgment of the High Court, restore the judgment of the family court. In that judgment, the Supreme Court has observed that for considering the dissolution of marriage at the instance of the spouse who alleged mental cruelty, the result of such mental cruelty must be such that it is not possible to continue with the matrimonial relationship. Mere wear and tear of the middle class family is not sufficient. The mental cruelty is of such that it is not possible to continue with the matrimonial relationship. By referring Samar Ghose and Jaya Ghose, their lordships has observed that where inference of mental cruelty could be drawn, even while emphasizing that no uniform standard can be laid down, and each case will have to be decided on its own facts. Here I will test and focus that each case will have to be decided on its own facts. Therefore, I will request the advocates, their pleadings are very much important, so also the evidence. The matrimonial cases are only based on the facts of the each case. The facts of the each case is very much important, and pleadings are very much important in matrimonial cases. The further their lordships has held that the respondent had made several defamatory complaints to the appellant's superiors in the army, for which a court of inquiry was held by the army authorities against the appellant. Primarily for those, the appellant's career progress got affected. The respondent was also making complaints to other authorities, such as the State Commission for Women, and has posted defamatory materials on other platforms. The net outcome of the above is that appellant's career and reputation has suffered. Therefore, this is more than sufficient to come to conclusion that there is a mental cruelty, as she is unable to prove that there is a adultery committed by the husband. Therefore, pleadings from this, we are required from their judgment, we can say that facts of the each case is required to be considered independently. And at the time of considering and assessing, evaluating the evidence and the pleadings of the parties, the court is required to look into the social status, educational qualification of the parties, and in what circumstances they live together, is required to be taken into consideration. Now, next I move to another judgment. Now the question is whether subsequent events happened during the pendency of the petition before the court can be considered in ascertaining whether there is a mental cruelty or not, is to be seen. The facts of the case are that it is the case of the husband that wife left the marriage hall late night on the day of the marriage itself. Wife left the marriage hall on the ground that she has not given her free consent. Due to coercion, her consent was taken and she left the marriage hall itself. On the contrary, wife has taken contention that there was a demand of dowry in the marriage hall by the relatives of the husband. That demand was not fulfilled. Therefore, brother of the husband has taken away her from the husband, and she filed a petition for restriction of conjugal rights. The husband has filed petition for divorce. Both matters are tried together, and before the trial court, family court, the trial took place. Trial took 5 years period of time, and ultimately, after 5 years, the family court has decreed the petition of the husband and dismissed the petition of the wife. The family court has given its reason that first day of the marriage, it is an admitted fact that first day of the marriage there is a separation. Marriage is not consummated. The grounds are different, but separation is admitted. There are already 5 years lapsed. The marriage is irrevocably broken down. Then wife went to the appeal to the High Court. High Court reversed the judgment of trial court, that is family court. Then husband approached the Supreme Court. In the meanwhile, during pendency of the petition, before the family court, high court, more than 11 years expired. In the meantime, and while during pendency of the petition, there are many subsequent circumstances. The respondent wife has filed writ petition praying for writ of mandamus to initiate disciplinary action against the appellant, who was working as an assistant professor in the Department of History of Government Arts College, and she has filed application for RTI for supplying the information regarding the service conditions of the husband, and she has preferred appeal that information furnished by the concerned authority is not sufficient, and then she has preferred a writ petition, another writ petition, even though information is already given with reference to whether he has second marriage, he has married second, he has undergone second marriage or not. That information was already furnished, and she know that after 6 years after the divorce decree is passed, the husband has undergone second marriage. She has filed that petition, and she has made representation to the college to make a disciplinary inquiry to the against the husband with reference to second marriage. Several instances have happened after filing the petition. The question is whether subsequent events can be considered in deciding whether there is a mental cruelty or not. That was dealt with by the Honorable Supreme Court. The Supreme Court has held that the subsequent event can also be considered, and by considering those conduct and behavior of the wife after filing the petition, approaching the different authorities by filing petitions, complaints, is amounts to a mental cruelty, and divorce was granted. I has referred this. There are several such cases are there. You can take benefit of this judgment, even though subsequent events, you can file a petition for. They have exercised jurisdiction under Section 1, Article 142 of the Constitution, but the trial the advocates practicing before the family court can take benefit of this petition for filing an amendment petition, adding the grounds of mental cruelty by taking the help of the principle laid down by their lawsuits in this judgment. I will give the citation in the next page PPT. I will discuss another case with reference to mental cruelty. This is a very beautiful judgment. What is required to be considered at the time of deciding mental cruelty, all principles are narrated here with reference to earlier judgments of the Supreme Court. In this, the facts of the case are that both petitioner and respondent, husband and wife, were friends from childhood. They were knowing each other since from 1966. They studied together in the same school. They were very close since 1974. After a friendship of more than a decade, they decided to marry. There was an intercaste marriage. It was an intercaste marriage, and initially the parents were opposed, but ultimately they have agreed and marriage was solemnized. The wife has a brilliant academic career. She has been recipient of prestigious Lahore Foundation Fellowship of United States of America offered to a young scientist for outstanding performance in the area of research. The case of the husband is that she is only focusing her career. She is not discharging her marital obligations without his knowledge or information. She has terminated her pregnancy twice. It amounts to mental cruelty to him. The respondent has admitted the termination of pre-pregnancy in her objection, but she has taken contention that she became pregnant within a 1 month, in a 1 month of the marriage, and that pregnancy was terminated with the consent of the husband, as due to the nature of her work, being exposed to harmful radiations as a part of a lab work of her PhD, it will affect the child in the womb. Therefore, with consent, they have decided to terminate the pregnancy. With reference to second pregnancy in 1985, she has become once again pregnant. Due to her acute kidney infection, she was terminated her pregnancy with the consent of the husband. With reference to her third pregnancy in the year 1989, she has taken contention that it was natural abortion. It was not termination. It was a natural abortion. And her specific case is that she was awarded a prestigious fellowship of United States. Therefore, instead of appreciating her academic career, he has jealous filed this petition. It is her case. Now the question is whether the termination of pregnancy, admittedly there are three pregnancies, two termination of pregnancy. One, she has taken contention that it is a natural one. The husband's case is that without his information, without his consent, she has terminated pregnancy. Whether it amounts to mental cruelty or not is considered. Here, once again, their lawsuits have considered what is required to be considered in deciding whether there is a mental cruelty to the spouse or not. The general rule in all cases of cruelty is that the entire matrimonial relationship must be considered. At the time of considering cruelty, whether there's a cruelty or not, the entire matrimonial relationship must be considered. And that rule is of special value when the cruelty consists not of a violent acts, but injurious reproaches, complaints, accusations. It is the effect of the conduct rather than its nature, which is the paramount importance in assessing a complaint of cruelty. Their lordships further held that the court should bear in mind the physical and mental condition of the parties, as well as their social status, and should consider the impact of the personality and conduct of one spouse on the mind of the other, weighing all incidents and quarrels between the spouses from that point of view. Further, the conduct alleged must be examined in the light of the complainant's capacity for endurance and extent to which that capacity is known to the other spouse. In this case, ultimately, the Supreme Court held that the termination of pregnancy by the wife is her sole decision, and it amounts to mental cruelty, and decree of divorce was granted. In deciding that facts, their lordships further observed that each case depends on its own fact and must be judged on these facts. The concept of cruelty has varied from time to time, from place to place, and from individual to individual in its application according to social status of the persons involved and their economic conditions and other matters. It is very important. The mental cruelty is not same to all. It is varied from time to time. It depends on culture, social background, and conduct or human behavior, and from place to place. Some given facts must be a cruelty to one person, but same set of facts will not be a cruelty to other. Here I can give one example. The wife used to, both are working as a teachers. Wife used to give entire salary, the entire bank account is under the control of husband. There is a strong trust between them. She has got a trust on the husband that her amount and earnings of the husband will be used for the benefit of the family. She has no grievance at all, no hesitation in giving all her income to the husband. And out of income of both husband and wife, they have purchased the property. There is no question of amount of wife and husband. There is so much of strong bondage between the husband and wife. In such case, there is no cruelty of handing over the entire earnings of the wife to the husband or entire earnings of the husband to the wife, vice versa. If both are working, either husband or wife is asking for each minute account of the salary, and both are IAS officers. Due to their official commitments, they are required to spend amount. Then asking account for each paisa will amounts to a cruelty to the other spouse. Therefore, the cruelty, mental cruelty, is differ from person, individual to individual, from place to place, varied from time to time. From all these aspects, from going to the three judgments, we can come to, I can say that the conclusions for how to ascertain the cruelty, mental cruelty. To prove mental cruelty, one must prove that the result of such mental cruelty must be such that it is not possible to continue with the matrimonial relationship. While considering the mental cruelty, no uniform standard can be drawn, and each case will have to be decided on its own facts. The question of mental cruelty has to be considered in the light of the norms of marital ties of the particular society to which the parties belong, their social values, status, environment in which they live. Courts are required to probe into the mental process and the mental effect of incidents that are brought out in evidence. I focus that are brought out in evidence. Therefore, the pleadings and evidence is very much important before the family courts in dealing with the matrimonial cases. Concept of cruelty has varied from time to time, from place to place, and from individual to individual in its application according to social status of the persons involved and their economic condition and other matters. Merely because there are allegations and counter allegations, a decree of divorce cannot be followed, nor there is no delay in disposal of divorce proceedings by itself is a ground to come to conclusion that marriage is irrevocably broken down. There must be some extraordinary features to warrant the grant of divorce on the basis of pleadings and other admitted materials. This is with reference to mental cruelty, and large number of cases will be filed under section 1311B, that is desertion. In all these three cases, the ground of desertion is also made. In one case, the desertion, on the ground of desertion, decree was sought for by the husband. The Supreme Court has granted decree. The conditions or requirements of desertion was not fulfilled, and 2 years was not expired, but by invoking the jurisdiction, the Supreme Court has granted decree for divorce on the ground of mental cruelty, even though the relief was not sought on that ground. I will read section 13(1)(b). Has deserted the petitioner for continuous period of not less than 2 years immediately preceding the presentation of the petition. To fulfill the requirements of section 13(1)(b), 2 ingredients are required to be fulfilled. One is 2 years expiration of 2 years period prior to the presentation of petition from the date of desertion, and animus mental status that with an intention not to rejoin, they have other spouse has deserted the petitioner is required to be proved. I have come across some petitions that even the ground is made out, but first 2 years period is not completed as per their own pleadings. Therefore, the first requirement is to grant a desertion is fulfillment of expiry of 2 years prior to presentation of petition is necessary. I will not deal with the facts, only principles. I want to say another our High Court judgment. If section 13(b) petition is filed after expiry of more than 10 years from the date of desertion, whether decree can be granted or not. It was considered by our own High Court. Under section 23, the parties are required to approach. There is no unreasonable delay in approaching the court. On that ground, the desertion was not considered. The other grounds are also dealt with in that judgment, that the evidence was given by 3 daughters. Husband himself has deserted the wife. The wife is with the 3 daughters, and the daughters' evidence was recorded before the court. The court has observed that in the matters involving the family issue, the family members are the best persons to speak about the in-house affairs, as they are the persons who could have the knowledge of such affairs. RW 2 to 4, the daughters in one voice say that respondent himself deserted the appellant and started living separately. Both the parties claimed that due to untimely death of their son in the year 1984, both of them were shattered. Under such critical condition, if the mother lives with the daughter it does not amount to cruelty to the respondent, nor any exception could be taken to that. Therefore, requirements delay is also a ground for objecting the petition under section 13(1)(b). I have repeatedly saying that pleadings are very much important before the family courts in matrimonial cases. Now the question is whether the barred allegations are general allegations against the respondent regarding cruelty are sufficient to come to conclusion or not. In one petition, it is alleged that from the beginning of the marital life, the respondent developed some sort of prejudice against him, and she started behaving strangely, attributing cruelty upon him, abusing him in most indecent and filthy language. She used to say, "You are not fit to be my husband." Respondent is very adamant, egoistic, and negative thinker. Husband has filed a petition for divorce against the wife by making these allegations. No incident. Why? What is the reason for quarrel? Was not at all pleaded. Why she has why she has developed prejudice against the husband is not at all pleaded. Are incidents on what context there was a quarrel between them, what is the incident and how it has impacted on the husband are not at all pleaded. Therefore, husband is not successful in getting a divorce. On the contrary, during the course of cross-examination, he has admitted that the wife is taking care of her mother-in-law and his mother. She has also taken care of daughter. Initially, he was paying maintenance to his mother, and stopped paying maintenance. Both have purchased one flat. He has failed to continue to pay the EMI. Thereafter, wife continued to pay the EMI. And there is no specific allegation against mental cruelty with reference to incidents. Only on that ground, he was failed to prove mental cruelty. Therefore, in a nutshell, I want to say that pleadings are very much important to decide the cruelty or mental cruelty. Now, another question is that the restitution of conjugal rights petition is filed by the husband. After referring the matter to the mediation, matter was not settled. He withdrawn the petition, and thereafter he filed petition for dissolution of marriage on the ground of cruelty. Whether the grounds prior to filing a restitution of conjugal rights petition are available to the petitioner to prove mental cruelty. Whether the filing of a petition for restitution of conjugal rights amounts to condonation of such behavior or act of a respondent. This will deal with, it can be section 23(1)(b) of the Hindu Marriage Act deals with this aspect. If that is the case, then he is required to prove that even though he has filed a petition for restitution of conjugal rights, he has not condoned the act or behavior of the respondent. Only on his proof of such that he has not condoned, then only he is entitled for dissolution of marriage, otherwise not. It amounts to filing of a restitution of conjugal rights amounts to condonation of act or behavior, alleged act or behavior of cruelty of the other spouse. This is with reference to cruelty. What is the time? Oh, already time is over. Custody, more focus on custody. Can I continue?
Ma'am, please continue, ma'am, because the today's highlight is child custody. So
Yes,
we
yes.
will not skip that main aspect.
13B, I will not. I will skip 13B.
We will
No,
skip 13B, and we
13.
will
Yeah.
we can now shift to this child custody.
Child
Yes.
custody. Child custody. Okay. Custody. My earnest request to the advocates who are practicing before the family court are matrimonial cases. In request, with reference to the dispute between the spouses regarding the custody of the child, you are required to advise them as by telling the impacts of their dispute. I have noticed that in some cases, the spouses will use child as their own weapon to trouble other spouse. That will not happen. It will has got different impact. Now I will directly go to the principles governing the custody of the minor children. Section 26 and 18 are there. In deciding a difficult and complex questions as to the custody of a minor, a court of law should keep in mind relevant status and rights following therefore. Such case cannot be decided solely by interpreting legal provisions. It is a human problem and required to be solved with human touch. While dealing with the custody cases, court is neither bound by statutes nor by strict rules of evidence or procedure nor the precedents. I will repeat. While dealing with custody cases, court is neither bound by statutes nor by strict rules of evidence or procedure nor by precedents. Paramount consideration should be the welfare and well-being of the child. To consider welfare or well-being of the child, court is to give due weight to the child ordinary comfort, contentment, health, education, intellectual development, and favorable surroundings. Over and above the physical comforts, moral and ethical value cannot be ignored. At the time of considering custody, all these facts are required to be considered. Child ordinary comforts, health, education, intellectual development, favorable surroundings, ethical values, and moral values. If the minor is old enough to form an intelligent preference or judgment, the court must consider such preference as well, though the final decision should not rest with the court. Final decision rests with the court as to what is conducive to the welfare of the minor. If child is in a position to form an opinion, then court should give weightage to such opinion, even though decision is of the court, but it should be considered. The controlling consideration governing the custody of the children is the welfare of the children and not right of their parents. The statutory provisions dealing with the custody of the child under any personal law cannot and must not supersede the paramount consideration as to what is the conducive to the welfare of the minor. I can repeat, personal law will not come in the way. Personal law will not come in the way in deciding the custody if welfare of the child is the paramount consideration. There are no rights of the parents which have to be enforced. The child is not a chattel or a ball that is bounced to and fro the parents. The custody of the child less than 5 years of age should ordinarily be with the mother. Exceptions can be, the deviation can be made only on strong reasons. What is the wish or desire of the child can be ascertained through interaction. But then the question as to what would be the best interest of the child is a matter to be decided by the court, taking into account all the relevant circumstances. Stability and security of the child is an essential ingredient for full development of the child's talent and personality. Any interim order or final order passed in the petition are not reached finality, or we can't say that the subsequent petition is amounts to res judicata. Under section 26 itself says that they can be modified, reviewed in view of the changed circumstances. There is no final, it can't be said that the second petition, either for custody or visitation right, is barred by principles of res judicata. With reference to two judgments, I want to deal with the custody matter. I chose these two judgments. In one judgment, the natural biological father filed a writ of mandamus against his own sister, asking custody of the child. Twins were born to the couple. As when they are two daughters, twins, were 3 or 4 months old, at that time, both parents, biological parents, decided that it is not possible to take care of both kids. Therefore, custody of the child is voluntarily handed over to the sister of the husband, sister of the father. Since from 3-4 months, one child was given to sister of the husband. When child was 14 years old, the husband, that is the father, approached the court and asked for custody of the child. It is the specific case of the respondent, the sister of the father of the child, is that at the time of marriage, at the time of taking possession of the or custody of the child, she was unmarried. Thereafter, marriage was performed, and she has delivered 2 other children, and she has taken care of that daughter even after marriage along with her husband. They have treated her as their own daughter. The court has interacted with the daughter. She was 14 years of the age. She was able to form an opinion. In that case, their lordships held that even though the petitioner father is the biological father and natural guardian under the laws, personal laws, but custody cannot be given to the father, as the child has expressed her intention that she was more comfortable with parents, with the sister, and she has also got other two siblings. She wants to stay with that siblings. In that, the right of the High Court has allowed the petition, as it is the right of the biological father and mother to have a custody, and his petition was allowed. The sister has approached the Supreme Court, and Supreme Court held that in that contest, the child is not a chattel or a ball. Observation was made. I have already read that observation. Even though, therefore, I am more focusing on the fact that law will not come in the way if welfare of the child is paramount consideration, welfare of the child is important, then court can deviate it, any statute also. Even personal laws, in the said judgment, their lordships have observed that the court can deviate it on the personal laws, and in this case, biological parents have sought for custody of the child, considering from 3 to 4 months baby, the child was with the sister of the biological father. And after marriage, her husband also treated this girl as their daughter. And the feelings between the other siblings, other two children born to the sister, are as a natural sister, like a natural siblings. Therefore, the Supreme Court has observed that it is not the right of the parents. We are required to consider the minor's interest, and paramount consideration is the welfare of the child. And interaction, with reference to interaction, I want to say something here. 4 years or 4 to 6 years kids can't form any opinion. But while discharging my duties as a principal judge, Family Court, Bangalore, I used to interact with the children. I never asked the questions directly to the children. What is their preference? Initially, I used to interact with the child alone. During that interaction, I used to ask general questions to know that whether child is a social child or not, whether what is his response about his school, what study, what is his interest, in what subject he is more interested, what is the boring subject, what the food he like, what he used to take in a box for a carry for what is the mode of transport. So such questions I used to ask. During my interaction, other spouse, which is not in the custody of the child, will be called to my chamber to know that what is the reaction of the child after entry of the other spouse. That is, based on that observation, I used to decide the custody matters. Here I can share one example, one case. The advocates will come to know that I will interact with the children. The child, 4 years child, was brought by the mother. It was sleeping, and told that it was sleeping. Therefore, I interacted the child along with the parents. When I saw my mobile child wake up and started interacting with me, and when father has showed the mobile, he has identified all the photos and asked the question to the child, "Oh, father, are you in Bengaluru?" Then we can observe what is the interest of the child, even though direct questions is not necessary. Similarly, 11 months babies, another case is there. I have referred in the PPT, time is over. I want to cover only 2 minutes. Parental alienation syndromes. In these, there is a concept of parental alienation syndromes. What is therefore, the parental alienation syndromes. Parental alienation represents a child's experience of being manipulated by one parent to turn against the other parent and resist the contact with him or her. This alienation with one parent and rejection of the other most often arises during child custody dispute following divorce or separation proceedings. If a child without any reasonable cause denies to even face to other parents, it reflects that child has been brainwashed and has been turned against the specific person. What is the impact of such alienation? Child alienation is, as per the research articles, the symptoms which are commonly reflected by parental alienation syndromes are that child's feelings of love towards one parent is replaced with the intense hate. It is the consequences of the parental alienation. Therefore, I have requested the advocates to guide the clients properly if they come with there is a dispute regarding the custody. The child's feeling of a love towards one parent is replaced with the intense hate. The vulnerability of the child is not consistent with his or her age, as the language leads to derogatory remarks against the rejected parents. Derogatory remarks against the rejected parent. No one is perfect and has flaws. The child here outweighs all the positive qualities or flaws, and she rejected the parents as all bad parents. The impact will be more dangerous on the child. The child would likely to display independent thinker phenomena, as the child would mirror the alienator dissolution system. The child experiences an intense fear of losing a relationship with only person in the world who loves him and support him. The child will overlook every good quality of rejected parents and would discriminate him or her on every minor flaws. One mother who was diagnosed with the migraines was labeled as a drug abuser. This is the consequence. Therefore, the parental alienation, now I have come across in several cases, there is a parental alienation. Therefore, at the initial stage, the parties are required to be guided. Our time is over. I will conclude here.
Thank you, ma'am. It was a very insightful session. Before we wind up the session, we'll take a few questions. Practically, you may address those questions, ma'am, which you would have encountered as a judge, as a presiding officer, and more particularly as a judge of the family court. Now, we'll start with few, not the questions on the chat box, but we'll directly take it. Yes. I would request mediator Hamsa ma'am. Hamsa ma'am, I'm giving you the option to unmute. Yes, ma'am, I have given you the option.
Okay. Good evening, madam. I have one question about the judicial separation. What is the parental role? Will the parents have legal responsibility of the children about maintenance and custody during judicial separation, madam? I'm asking about.
Yes. It is what is available in section 13 if they are residing separately, same
Yes.
thing is applicable.
Same is applicable.
Yes,
Okay.
yes. Yeah, after the divorce decree, what is the
Provisions.
for custody provisions? They are applicable to the judicial separation also.
Okay. At that point of time, can the wife also claim maintenance during judicial
Yes.
separation?
She can claim maintenance.
Okay. Okay. Thank you.
Before we take up the next question, ma'am, I have a personal question. These days,
Yeah.
what we are encountering is, in few cases, in genuine cases, the child is also not very receptive to the father, perhaps. And in few cases, it would be the child would be tutored also. In these cases, how have you tackled that practically?
There are different cases. Can I answer? It is near to my heart. This question is near to my heart.
Yes, ma'am. Yes,
I can answer in Kannada.
Definitely.
In some cases, ಆಗ್ಲೇ ಹೇಳ್ತಾ ಇದ್ದೆ, ನಾನು ಒಂದು ಎಕ್ಸಾಂಪಲ್ ಹೇಳ್ತಾ ಇದ್ದೆ ನಿಮಗೆ. 4 ವರ್ಷದ ಮಗು, ನಾನು ಮಕ್ಕಳನ್ನ ಇಂಡಿವಿಜುವಲ್ ಆಗಿ ಇಂಟ್ರಾಕ್ಟ್ ಮಾಡ್ತೀನಿ ಅಂತ ಗೊತ್ತಾಯ್ತು. ಮಗು ಮಲಗಿದೆ ಅಂತ ಮಧ್ಯಾಹ್ನ ಹತ್ಕೊಂಡ್ ಬಂದ್ರು, ತಾಯಿ ಕರ್ಕೊಂಡ್ ಬಂದ್ರು ಮಗುವಿನ, ಎಬ್ಸಿದ್ರು, ಹೇಳಿಲ್ಲ. ಅದು ಮಗು ಹೇಳಿಲ್ಲ ಅಂತ ಹೇಳಿದ ಕೂಡಲೇನೆ ಕರ್ದಾಗ ಅದು ಕಣ್ ತೆಗೆದು ನೋಡ್ತಿತ್ತು. ನಾನು ಒಂದ್ಸರಿ ನೋಡಿದೆ, ಏನ್ ನಿನಗೆ ಇಂಟ್ರೆಸ್ಟ್, ಏನು ಚಾಕ್ಲೇಟ್ ಏನೋ ತೋರಿಸ್ಬೇಕು, ಏನೋ ಆಗ್ಲಿಲ್ಲ. ಕಡಿಕ ನಾನು ಐ ಟುಕ್ ಮೈ ಮೊಬೈಲ್ ತಗೊಂಡೆ. ನಂದು ಮೊಬೈಲ್ ತಗೊಂಡು ಅದರೊಳಗಿಂದ ಇದ್ರೊಳಗ ನೀನ್ ನೋಡ್ತೀಯ ಅಂತ ಹೇಳಿ ಆನ್ ಮಾಡಿದ ಕೂಡಲೇ ಮಗು ತಾಯಿ ತೊಡೆಯಿಂದ ಎದ್ದು ನನ್ನ ಕಡೆ ಬಂತು ಬೇಬಿ ಬಂದು. ಆವಾಗ ಐ ಹ್ಯಾವ್ ಆಸ್ಕ್ಡ್ ಟು ಡ್ರಾ. ನಂದು ಮೊಬೈಲ್ನೊಳಗೆ ಅದಿದೆ, ಒಂದು ಪೆನ್ ಇದೆ. ಆ ಪೆನ್ ಇಂದ ಡ್ರಾ ಮಾಡೋದಕ್ಕೆ ಕೊಟ್ಟೆ ಮಗುವಿಗೆ. ಡ್ರಾ ಇನ್ ಮೀನ್ ಟೈಮ್ ಐ ಆಸ್ಕ್ ದಿ ಫಾದರ್ ಇನ್ ಪ್ರೆಸೆನ್ಸ್ ಆಫ್ ಎ ಮದರ್ ಓನ್ಲಿ ಟು ಇಂಟ್ರಾಕ್ಟ್ ವಿತ್ ದ ಚೈಲ್ಡ್ ಜೋಡಿ ಇಂಟ್ರಾಕ್ಟ್ ಮಾಡಂದ್ಕೂಳೆ he got the point. He started showing his mobile. ಅವನು ಮಗುವಿನ ಪಿಕ್ಚರ್ ಇದ್ದು ಎಲ್ಲ ತೋರಿಸಿದ್ರು. ಅವರ ಕಜಿನ್ ಬ್ರದರ್, ಆ ಮಗುವಿನ ಕಜಿನ್ ಬ್ರದರ್ ಒಂದು ಗ್ರೀಟಿಂಗ್, ದೀಪಾವಳಿ ಸನಿಪ್ ಬಂದಿತ್ತು, ಗ್ರೀಟಿಂಗ್ ಮಾಡಿ ಕಳಿಸಿತ್ತು, ಹ್ಯಾಂಡ್ ಮೇಡ್ ಗ್ರೀಟಿಂಗ್ ಕಳಿಸಿತ್ತು. ಅದನ್ನ ಕೊಟ್ಟ ಫಾದರ್ ಮಗುವಿಗೆ. ಅದನ್ನ ನೋಡಿ ಬಹಳ ಖುಷಿ ಆಯ್ತು ಮಗುವಿಗೆ. ದೆನ್ ದ ಚೈಲ್ಡ್ ಹ್ಯಾಸ್ ಆಸ್ಕ್ಡ್ ಕ್ವಶನ್ ಟು ದ ಫಾದರ್, ಆರ್ ಯು ಇನ್ ಬೆಂಗಳೂರು ಹೇಳ್ತು. ದೆನ್ ಅಂದ್ರೆ ಅದಕ್ಕೆ ಏನಾಯ್ತು, ವಿ ಕ್ಯಾನ್ ಗೆಸ್ ಇಟ್. ಆ ಮಗುವಿಗೆ ತಂದೆಯ ಬಗ್ಗೆ ಯಾವುದೇ ನೆಗೆಟಿವ್ ಥಿಂಗ್ಸ್ ತಲೆಯೊಳಗಿಲ್ಲ, ಮಗುವಿನ ತಲೆಯೊಳಗಿಲ್ಲ. ಅವಾಗ ನಮ್ಗೆ ಡಿಸಿಷನ್ ತಗೊಳಕ್ಕೆ ಬಹಳ ಇದಾಗುತ್ತೆ. ಇನ್ ಸಮ್ ಒಂದೇ ಕೇಸ್ನೊಳಗೆ 3-4 ಸರಿ ಆರ್ಡರ್ಸ್ ಮಾಡುವಂತ ಪ್ರಸಂಗ ಬಂತು. ಬೋತ್ ಆರ್ ವೆಲ್ ಎಜುಕೇಟೆಡ್. ಈಗ ಅಲ್ಲಿ ಪೇರೆಂಟ್ಸ್ಗೆ ಹೇಗೆ ಮಾಡ್ತಾ ಇದ್ರು ಅಂತ ಹೇಳಿದ್ರೆ, ಬೋತ್ ಪೇರೆಂಟ್ಸ್ ಯೂಸ್ ಟು ಫೈಟ್ ಫಾರ್ ಶೇರ್ಡ್ ಕಸ್ಟಡಿ. ಮಕ್ಕಳ ಸ್ಥಿತಿ ನೋಡಿದ್ರೆ ನಮಗೆ 2-3 ಸರಿ ಮನೆ, ಅವಾಗ ಅಂತ ಕೇಸಸ್ ಅನ್ನ, ಸೆನ್ಸಿಟಿವ್ ಮ್ಯಾಟರ್ಸ್ ಅನ್ನ ನೋಡಿದಾಗ ಅದನ್ನ ಮನೆಗೆ ಬಂದ್ ಸರಿಗ್ ಶೇರ್ ಮಾಡ್ತೀನಿ. ಅವತ್ತು ಇಡೀ ದಿನ ನಮಗ್ ಅದೇ ಇರುತ್ತೆ ತಲೆಯೊಳಗೆ. ಆ ಮಗುವಿಂದು ಇಬ್ರು ಮಕ್ಕಳು ಬಂದು ಇಂಟ್ರಾಕ್ಷನ್ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದ್ದಾದ್ಮೇಲೆ ಆಮೇಲೆ ಪೇರೆಂಟ್ಸ್ ಅನ್ನು ಕಳಿಸಿದ್ಮೇಲೆ ಮದರ್ ಕಸ್ಟಡಿ ಇರ್ಲಿಲ್ಲ, ಫಾದರ್ ದೇ ಆರ್ ಇನ್ ದ ಕಸ್ಟಡಿ ಆಫ್ ಫಾದರ್. ಮದರ್ ನೋಡಿ ಫಾದರ್ ಹೊರಗೆ ಕಳ್ಸಿದ ಕೂಡಲೇನೆ ಮದರ್ಗೆ ಐ ಆಸ್ಕ್ ದ ಮದರ್ ಟು ಇಂಟ್ರಾಕ್ಟ್ ವಿತ್ ದ ಚಿಲ್ಡ್ರನ್. ಅವ್ರು ಒಂದ್ ಸ್ವಲ್ಪ ಹಿಂಗ್ ಹೋಗಿ ಮುಟ್ಟಿ ಹೇಳ್ಬೇಕು ಅಂತ ಸಣ್ಣ ಮಗುನ್ ಹೇಳಿದ್ರೆ ಅಪ್ಕೊಂಡು ಬಿಕ್ಕಿ ಅಳಕ್ ಸ್ಟಾರ್ಟ್ ಮಾಡಿದ್ರು. ಹೊರಗೆ ಇವನ್ನೆಲ್ಲ ನಾವು ಇದ್ರಾಗ ಬರ್ತಿರ್ದಿಲ್ಲ ಕೆಲವೊಂದು, ಅಂದ್ರೆ ಇಟ್ ವಿಲ್ ಇಂಪ್ಯಾಕ್ಟ್ ಅಂದ್ರೆ ಅದರ ಇದಕ್ಕೆ ಆಗತ್ತೆ ಅಂತ ಬರೆಯಂಗಿಲ್ಲ. ಆದ್ರೆ ಅವಾಗ ನಮಗ್ ವಾಟ್ ಈಸ್ ದ ಬೋತ್ ಪೇರೆಂಟ್ಸ್ ಬೇಕ್ರಿ. ಎಲ್ಲಾ ಯಾವ ಚೈಲ್ಡ್ ನೋಡಿದ್ರು ಇಬ್ರು ಪೇರೆಂಟ್ಸ್ ಬೇಕಂತ ಹೇಳ್ತಾವ ಮಕ್ಕಳು. ಒಬ್ಬರಿಗೆ ಪ್ರಿಫರ್ ಮಾಡೋದಿಲ್ಲ, ಇಲ್ಲ ಎರಡೂ ಮಕ್ಕಳು ಬೇಕೇ ಅಂತ ಹೇಳ್ತಾವ. ಆದ್ರೆ ಇನ್ನು ಒಂದು ಕೇಸ್ನೊಳಗೆ ರೀಸೆಂಟ್ ಆಗಿ ನಾನು ಒಂದ್ ವಾರದ ಹಿಂದೆ, ಬಿಫೋರ್ ರಿಟೈರ್ಮೆಂಟ್ 1 ವಾರದ ಹಿಂದೆ ಒಂದು ಕೇಸ್ ಮಾಡಿದ್ದೇನೆ. ಅದ್ರೊಳಗೆ ಏನಾಯ್ತು ಅಂತ ಹೇಳಿದ್ರೆ, ಚೈಲ್ಡ್ ಈಸ್ ನಾಟ್ ರೆಡಿ ಟು ಗೋ ಟು ಫಾದರ್. ಮಾತಾಡೋದಕ್ಕೂ ರೆಡಿ ಇಲ್ಲ. ಕೆಲವೊಂದು ಅಲಿಗೇಷನ್ಸ್, ಈಗಿನ ಸಿಚುವೇಶನ್ಸ್ ಹ್ಯಾಂಗ್ ಬಂದಿದೆ ಅಂದ್ರೆ, ಕೆಲವೊಂದು ಅಲಿಗೇಷನ್ಸ್ ಎಷ್ಟು ಗ್ರೀವಿಯಸ್ ಇರ್ತಾವು ಅಂತ ಹೇಳಿದ್ರೆ, ಅಸಾಲ್ಟ್ ಮಾಡಿದ್ದು ಮಗುವಿನ ಒಂದ್ ಸ್ವಲ್ಪ ಫೋಟೋ ಹಾಕಿದ್ರು, ಮಗುವಿಗೆ ಸ್ಕಿನ್ ಅಲರ್ಜಿ ಇದೆ, ಸ್ಕಿನ್ ಅಲರ್ಜಿ ಆಗಿರೋದು ಫೋಟೋ ಇದೆ, ಮಾರ್ಕ್ಸ್ ಫೋಟೋನು ಇದೆ. We can easily bifurcate what is the skin allergy injury, what is the injury. ಸ್ಕಿನ್ ಅಲರ್ಜಿ ಆಗಿರೋದು ಗಾಯ ಯಾವುದು ಅಂತಾನು ಗೊತ್ತು ಮಾಡ್ಕೋಬಹುದು, ಇದನ್ನ ಮಾಡ್ಬೋದು. ಅವಾಗ ನನಗೆ ಐ ಹ್ಯಾವ್ ಲಿಟಲ್ ಬಿಟ್ ಹೆಸಿಟೆಂಟ್ ಟು ಗ್ರಾಂಟ್ ಓವರ್ನೈಟ್ ಕಸ್ಟಡಿ. ಐ ಹ್ಯಾವ್ ನಾಟ್ ಗಿವನ್ ಓವರ್ನೈಟ್. ಇಫ್ ಅದು ಏನೋ ಡೌಟ್ ಬಂದ್ರು, ಇಫ್ ಚೈಲ್ಡ್ ವೆಲ್ಫೇರ್ ಇಸ್ ದ ಮೇನ್ ಕ್ರೈಟೀರಿಯಾ. ಈಗ ಯಾವುದೋ ಒಮ್ಮೆ ಅವನಿಗೆ ಯಂಗರ್ ಇಶ್ಯೂ ಇದೆ ಅನ್ನೋದು ಸಾಕಷ್ಟು ದೊಡ್ಡದು ಮಾಡಿದ್ರು, ಇವರು ಸಾಕಷ್ಟು ಮಟೀರಿಯಲ್ ಕೊಟ್ಟಾಗ ಅವಾಗ ಏನ್ ಮಾಡ್ತೀವಿ ಅಂತ ಹೇಳಿದ್ರೆ ವಿಸಿಟೇಷನ್ ರೈಟ್ ಆರ್ ಮಾನಿಟರಿಂಗ್, ಅಂದ್ರೆ ಏನಂತಾರೆ ಮಾನಿಟರಿಂಗ್, ಯಾವ ಸೂಪರ್ವಿಷನ್ ವಿಸಿಟೇಷನ್ ರೈಟ್ ಕೊಡ್ಬೇಕಾಗುತ್ತೆ ಅಂತ ಟೈಮ್ ಸೂಪರ್ವಿಷನ್ ಇದೆ ಅಂತ. ಅದು ಎಲ್ಲಾ ಕೇಸ್ನೊಳಗೂ ಹಂಗಾಗೋದಿಲ್ಲ, ಎಲ್ಲೋ ಇಲ್ಲೊಂದು ಕೇಸಸ್ ಹಂಗ್ ಬರುತ್ತೆ. ಉಳುಕಿದ ಕೇಸ್ನೊಳಗೆ ಚಿಲ್ಡ್ರನ್ಸ್ ಆಂಗಲ್ನಾಗ ನೋಡೋದಾದ್ರೆ ದೇ ವಾಂಟ್ ಬೋತ್ ಪೇರೆಂಟ್ಸ್. ಒಂದು ಕೇಸ್ನೊಳಗೆ ಪಾರ್ಟಿ ಇನ್ ಪರ್ಸನ್ ಬಂದಂತಹ ಕೇಸ್ನೊಳಗೆ ದಿ ಚೈಲ್ಡ್ ವಾಸ್ ಸೋ ಇದೆ ಅಂತ ಹೇಳಿದ್ರೆ, ಅದು ಈಗೇನ ಇಂಪ್ಯಾಕ್ಟ್ ಹೇಳ್ತಾ ಇದ್ನಲ್ವ ನಾನು, ಪೇರೆಂಟಲ್ ಎಲಿಮಿನೇಷನ್ ಇಂಪ್ಯಾಕ್ಟ್ ನೊಳಗೆ ಮಕ್ಕಳು ಲ್ಯಾಂಗ್ವೇಜ್ ಚೇಂಜ್ ಆಗುತ್ತೆ ಅಂತ. ಆ ಲ್ಯಾಂಗ್ವೇಜ್ ಚೇಂಜ್ ಆಗಿದ್ದು ಅಬ್ಸರ್ವ್ ಮಾಡಿದೆ ನಾನು. ಅದಕ್ಕೆ ದಿ ಥೆರಪಿ ಇಸ್ ನೀಡೆಡ್. ಅಂತ ಕೇಸನ್ನ ನಾವು ಡೀಲ್ ಮಾಡಕ್ ಆಗೋದಿಲ್ಲ. ಥೆರಪಿ, ಫ್ಯಾಮಿಲಿ ಥೆರಪಿ ಅಂಡ್ ಇಂಡಿವಿಜುವಲ್ ಥೆರಪಿ ಟು ದ ಚೈಲ್ಡ್ ಇಸ್ ನೀಡೆಡ್ ಅನ್ನೋ ಅಬ್ಸರ್ವೇಷನ್ ಮಾಡ್ತಾರೆ.
Madam, I have a question.
Yes.
What is your opinion about the shared parenting and shared custody? ನಿಮ್ಮ ಒಪಿನಿಯನ್ ಏನಂತ ಹೇಳುತ್ತೆ?
ಈಗ it depends on social status of the parties.
Okay.
Their upbringing. In some cases, shared custody will be harmful to the children. In some cases, it is benefit to the children.
Yes. Don't we think psychologically they should be having shared parenting?
In some parents will be like that.
ಮಕ್ಕಳ ಮೇಲೆ ಪ್ರಭಾವ ಬೀರುತ್ತೆ ಅಂತ.
ಅಲ್ಲ, ಮಕ್ಕಳ ಮೇಲೆ ಪ್ರಭಾವ ಆಗುತ್ತೆ. ಶೇರ್ ಕಸ್ಟಡಿಯಿಂದ ಪ್ರಭಾವ ಅಂದ್ರೆ ಮೀನ್ಸ್ ಅಲ್ಲೇ ಪೇರೆಂಟ್ಸ್ ಹೆಂಗ್ ಬಿಹೇವಿಯರ್ ಮಾಡ್ತಾರೆ ಅದ್ರ ಮೇಲೆ ಡಿಪೆಂಡ್ ಆಗುತ್ತೆ. ಶೇರ್ ಕಸ್ಟಡಿ ಒಳಗೆ ಅವ್ರ ಕಸ್ಟಡಿ ಇದ್ದಾಗ ಈಗ ಅಲ್ಲೇನ್ ಮಾಡಿದ್ವಿ, ಅಲ್ಲಿ ಯಾಕೆ ಹೋಗಿದ್ದಿ, ಇಲ್ಲಿ ಯಾಕೆ ಹೋಗಿದ್ದಿ ಅಂತ ಮಾಡಿದ್ರೆ ಇಟ್ ಈಸ್ ಎ ಟಾರ್ಚರ್ ಟು ದ ಚಿಲ್ಡ್ರನ್. ಒಂದ್ ಕೇಸ್ನೊಳಗೆ ನಾನು ಆರ್ಡರ್ ಮಾಡಿದೆ, ಅವರು ಎರಡೂ ಕೇಸ್ನೊಳಗೂ ತಮ್ಮ ಕಸ್ಟಡಿ ಒಳಗೆ ಬಂದಾಗ, ಶೇರ್ ಕಸ್ಟಡಿ ಕೊಟ್ಟಾಗ ಅವ್ರು ಏನ್ ಮಾಡಿದ್ರು ಅಂತ ಹೇಳಿದ್ರೆ ರಿಕಾರ್ಡಿಂಗ್ ಮಾಡಿದ್ರು, ವಿಡಿಯೋ ರಿಕಾರ್ಡಿಂಗ್ ಮಾಡ್ಕೊಂಡಿದ್ರು. ಮಗು ಕಂಪ್ಲೇಂಟ್ ಮಾಡೋದು ಫಾದರ್ ಕಡೆ, ಫಾದರ್ ಮಕ್ಕಳು ತಾಯಿ ಕಂಪ್ಲೇಂಟ್ ಮಾಡೋದು. ದೇ ಹ್ಯಾವ್ ವಿಡಿಯೋಗ್ರಾಫ್. ಅದು ದಟ್ ಈಸ್ ಹಾರ್ಮ್ಫುಲ್ ಟು ದ ಚಿಲ್ಡ್ರನ್. ಸಚ್ ಶೇರ್ ಕಸ್ಟಡಿ ಇಸ್ ಹಾರ್ಮ್ಫುಲ್. ಒಬ್ಬರ ಕಡೆ ಇರಬೇಕಾಗತ್ತ ಅಂತ ಕೇಸ್.
Thank you, madam.
We have one question from Mr. Nagabhushan, advocate. His question is, the MC case which was pending, where they had filed an application for the custody of child, was dismissed, and the prayer was very limited. Only during the vacation they had sought for the visitation rights, and that application was rejected, and MC petition is now disposed of. So he wants to know the recourse, whether he can now file a separate JNWC petition, or is he barred? That is a specific question.
The answer is section 26.
In fact, this you have mentioned while
yes.
you were presenting.
Detail ಆಗಿ ಹೇಳಕ್ಕೆ ಟೈಮ್ ಆಯ್ತು ಅಂತ ಹೇಳಿಲ್ಲ ನಾನು. ಇಲ್ಲಿ ಹೇಳ್ತೀನಿ. I will read it now. I will read the section 26. ಯಾವುದೇ ಆರ್ಡರ್ ಫೈನಲ್ ಆಗೋದಿಲ್ಲ. ಇವನ್ ಇನ್ ಎಕ್ಸಿಕ್ಯೂಷನ್ ಪಿಟಿಷನ್ ಆಲ್ಸೋ. ಎಕ್ಸಿಕ್ಯೂಷನ್ ಹಾಕಿದಾಗನೂ ಅದನ್ನ ಮಾಡಕ್ ಆಗೋದಿಲ್ಲ. ಇಲ್ಲೇ section 26, custody of a children. In any proceedings under this act, the court may from time to time pass such interim orders and make such provision in the decree as it may deem just and proper with respect to the custody, maintenance and education of a minor children, consistently with their views whenever possible, and may after the decree upon application by petition for the purpose make for time to time all such orders and provisions with respect to custody, maintenance and education of such children as might have been made by such a decree or interim orders in case of proceedings for obtaining such a decree were still pending, and the court may also, is important, from time to time revoke, suspend, or vary any such orders and provisions previously made. There is no res judicata, section 20. At any time in the changed circumstances, court can revoke, suspend, or vary the orders, such orders passed. Therefore, he can approach the court at any time. It will not a bar. It will not be a bar.
So now he can prefer for a separate petition itself.
Yes, he can file a separate petition.
Yes.
They will counter that already considered and rejected, but he is required to make a ground for his custody.
Mr. Yogendra has a question, but perhaps it's a very simple one. Is a pending 498A case against him, and the stage before the criminal court is here before charge. Can I see my daughter? She is 1.5 years old. So the answer is obviously you have a right, and I would request ma'am to throw some more light on this aspect.
He can see through the court by filing an application. By filing an application, court will consider what is the nature of the allegations made in that. Mere filing of a charge sheet is not a ground to reject the custody of the or visitation right, or phone calls, or video calls of the child. The court will look into the matter. He can file application, not directly, but through court he can see the child.
Perhaps even the conviction should not come on the way, even if there
yes, even the conviction will not come in the way.
So Yogendra, that is the answer for your question. Mr. Colin Ward has a very pertinent question, ma'am.
Yes.
Because sometimes due to various reasons, there is delay in disposing of the cases, especially with regard to child custody. And that delay might have caused the child to drift away from the non-custodial parent. What is your opinion?
There is a chance.
Because there could be sometimes 2 years of delay, and the child would have totally forgotten the other parent, the non-custodial parent.
Yes, there is such chances are there. I also felt, I have expressed that view before my judgment writer, that we have kept this for a long period of 9 years while dictating the judgment. What's the need? 16 ವರ್ಷ ಈಗ 2 ವರ್ಷ 3 ವರ್ಷದ ಮಕ್ಕಳಿದ್ದಾಗ 12 ವರ್ಷದ ಆದಾಗ ನಾವು ಜಡ್ಜ್ಮೆಂಟ್ ಬರೆದ್ರೆ ಉಪಯೋಗ ಆಗೋದಿಲ್ಲ. ಆದ್ರೆ ಏನ್ ಮಾಡ್ಬೇಕು ಅಂತ ಹೇಳಿದ್ರೆ ಅಂತ ಅಡ್ವೊಕೇಟ್ಸ್ ರೋಲ್ ಇಸ್ ವೆರಿ ಇಂಪಾರ್ಟೆಂಟ್. ಅವಾಗ ಇಂಟ್ರೀಮ್ ಇಮಿಡಿಯೇಟ್ಲಿ ಆಫ್ಟರ್ ಫೈಲಿಂಗ್ ದ ಈಗ ಸಪರೇಷನ್ ಆದಾಗ ಚೈಲ್ಡ್ಸ್ ಇದ್ರೆ ಅಪ್ಲಿಕೇಶನ್ಸ್ ಹಾಕೋಬಹುದು. ಇಂಟ್ರೀಮ್ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕೊಂಡು ಡ್ಯೂರಿಂಗ್ ಪೆಂಡೆನ್ಸಿ ಒಳಗನೆ ನೀವು ಇಂಟ್ರಾಕ್ಟ್ ಮಾಡ್ತಾ ಇರಲಿ, ಶೇರ್ ಕಸ್ಟಡಿ, ವೆಕೇಶನ್ಸ್ ನೊಳಗೆ ಹಾಫ್ ವೆಕೇಶನ್ಸ್ ಅವೆಲ್ಲ ಆರ್ಡರ್ಸ್ ಆಗಿದ್ರೆ ಈ ಒಂದು ಪ್ರಾಬ್ಲಮ್ ಬರೋದಿಲ್ಲ. ಅವಾಗ mere long pendency will not be a ground agodilla.
We have one question by Ms. Gayatri. Her question is, in few cases only WhatsApp interaction is permitted, and how would the non-custodial parent develop any kind of bondage merely with the online or the WhatsApp call?
Few cases ಒಳಗೆ ಅಂತ ಹೇಳಿದೆ ನಾನು. Repeatedly I have told that each case facts are required to be considered. ಯಾಕೆ ಕಸ್ಟೋಡಿಯಲ್ ಕೊಡ್ಲಿಲ್ಲ ಅಂದ್ರೆ, ಶೇರ್ಡ್ ಕಸ್ಟಡಿ ಆರ್ ವಿಸಿಟೇಷನ್ ಕೊಟ್ಟಿಲ್ಲ ಅಂದ್ರೆ ದೇರ್ ಆರ್ ಸಮ್ ಅದರ್ ಗ್ರೌಂಡ್ಸ್ ಇರಬೇಕು. ಎನಿ ಗ್ರೌಂಡ್. ಈಗ ಫಾರ್ ಎಕ್ಸಾಂಪಲ್ ಅಲ್ಲೇ ಈಗ ನಾನು ಮಗು 3-4 ತಿಂಗಳ ಇದ್ದಾಗಿಂದ 8 ವರ್ಷದ ಆಗುತ್ತ ನಾನು, ದೇರ್ ಇಸ್ ನೋ ಕನೆಕ್ಷನ್, there is no meeting of the father and the child ಅಂತ ಇದ್ದಾಗ ಸಡನ್ಲಿ ಒಮ್ಮೆಗಲೇ ವಿಸಿಟೇಷನ್ ಆಗಿರ್ಬೋದು ಅಥವಾ ಇದನ್ನ ಕೊಡಕ್ ಆಗೋದಿಲ್ಲ. ಆ ತರ ಏನಾದ್ರೂ ಕೊಟ್ಟಿರ್ಬೋದು, ವಾಟ್ಸ್ಆಪ್ ವಿಡಿಯೋ ಕಾಲ್ ಇದನ್ನ ಕೊಟ್ಟಿರ್ಬೋದು. ಇಟ್ ಡಿಪೆಂಡ್ಸ್ ಆನ್ ದ ಫ್ಯಾಕ್ಟ್ಸ್ ಆಫ್ ದ ಈಚ್ ಕೇಸ್.
And here, ma'am, most of the cases where they say that the child is not responding to the father in many of the cases, does the family court have any provision where the matter could be referred to a counselor? Sometimes we would
there is no idana, but
provision illa.
Judgments are there.
Because in
judgments are
many cases in the High Court, we have sought for such relief. But
Yes.
before the trial court,
ಎಸ್ ನನ್ ಮುಂದೆ ಒಂದು ಕೇಳಿದ್ರು, ಅದು ಆರ್ಡರ್ ಮಾಡೋದು ಆಗ್ಲಿಲ್ಲ ನನಗೆ. ಇನ್ವ್ಯೂ ಆಫ್ ಅದರ್ ವರ್ಕ್ಸ್ ಅದೊಂದು ಮಾಡೋಕೆ ಆರ್ಡರ್ ಆಗ್ಲಿಲ್ಲ. ದೇರ್ ಇಸ್ ಎ ಜಡ್ಜ್ಮೆಂಟ್ಸ್ ಆರ್ ದೇರ್. In such cases, court comes to the conclusion. In one case, ನಾನು ರೆಫರ್ ಮಾಡಿದ್ದೆ. One case ಒಳಗೆ I have referred the ಇದನ್ನ child for the examination.
right?
Yes.
Before we wind up the session, Mr. Biju, who is a mediator, has a question. I would request Biju sir to directly pose the question. He has in fact posted it in the Q&A box, but I would request Biju sir to pose the question directly. Sir, I am unmuting you. Yes, sir, you are unmuted.
Good evening, ma'am. It was a wonderful presentation. One whole day's presentation, you have reduced it into 1 hour. It was wonderful. Ma'am, my question is, in a case of child custody and the child is born through a surrogate mother, then can the wife claim custody of the child while the husband is actually the biological father? The child is only 5 years, 6 years of age.
Yes.
Immediately after getting the child, the mother files a divorce petition and tries to take the child custody, where the father is a biological father.
Yes. After the birth of the child.
Yes.
Whether they resided together?
They resided together. Together, but then she feels that, I should take the custody of. She feels that that the custody of the child will be taken over by the father, or the child is getting more attached to the father. So because of which mother takes away the child and vanishes.
Madam, 1 minute. I think before going for surrogacy, might be the consent of both the parents has been taken. So might be they will have equal rights about it.
Here, father is a biological
father. I agree with
father.
it. Yeah. Surrogacy, before going to surrogacy, you have to have a agreement done by both the husband and
all
wife.
that is done. All that is past.
Okay.
They live together with the child for 4 years.
Okay.
Then the mother has got right.
Yes.
Mother has a right to take the child and move away from the father who is the biological father.
One nimisha. Take the child antalla. They both have got equal
rights.
Right.
Yes.
Equal right to have custody.
Yes.
Yeah. Thank you, ma'am. Thank you.
All right, ma'am.
Thank you.
With this question, we will conclude today's session. Firstly, thank you so much for accommodating us. In this vacation, you have agreed, and you are so well prepared to give a very exhaustive presentation. In fact, due to the paucity of time, perhaps we have condensed it.
I have not dealt with maintenance.
Maintenance, and we will have part 2, ma'am. We will have part 2 some other day, so that maintenance and mutual consent divorce and perhaps declaration suits which are filed for declaring dissolution of marriage, those aspects also we'll cover it in some other session. On behalf of all our participants, on behalf of Advocates Association Bengaluru, Academy Bengaluru, all the office bearers, and my personal behalf, ma'am, many thanks to you. Thanks for this.
Thank you, madam.
Insightful,
Thank you very much.
Insightful session.
Thank you.
Thank you for the opportunity. Thank you.